As you know, YouTube's reach is worldwide. Occasionally, I get someone from another state to call me and ask me about their state's probate procedure. Of course, I explain to them that I'm not familiar with your state's probate procedure. As a result, I got curious and I decided to figure out what are the main differences of the probate procedure from state to state. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. In general, a probate process serves the same purpose from state to state, which is to settle a deceased person's estate, to transfer their remaining assets to their legitimate heirs or beneficiaries. Also, how assets end up in probate are relatively the same. Someone passed away with valuable assets still titled in their name. Here are some of the major or main differences in the state's processes or probate processes I've discovered. The size of the estate or the threshold dollar amount by which you can bypass a full probate procedure differs. In some states, that threshold amount is as low as $15,000. Here in the state of California, that threshold amount is $160,000. Currently, if your estate here in California is valued less than $160,000, you can use a small estate affidavit in order to settle that estate. Another major difference is what assets are used to determine that threshold dollar limit. In some states, real estate is used to determine that threshold dollar limit, and in other states, real estate is not used to determine that limit. Another major difference between the probate processes from state to state has to do with deadlines and the complexity of the estate. The probate process will inherently take longer to settle when the timelines or time frames are different from state to state. How long it takes for a probate procedure to settle depends on many factors. For example, here in the state of California, creditors have 4 months from the time that letters of testamentary have been issued to file their claims with the estate. In other states, creditors have only weeks to file their claims. In some states, a will need not be probated at all if the decedent died with no debt and had no real estate to distribute. Question of the day: have you ever probated an estate outside of the state of California? If so, was that process simple and short, or was it long and arduous? Let us know in the comments below. In order to determine the process or procedure of a probate in your county or the county where your loved one passed away, visit that website. Visit the probate section of that website, and that website will tell you how and what needs to be done in order to probate your loved one's estate. If you've gotten value from this video, be sure to like, share, and subscribe. I'm Daryl Williams. This is Win-Win Realtors TV. If you have any questions for me, my contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need legal advice, please contact an attorney. If you need an estate planning attorney or a probate attorney here in the Southern California area, feel free to contact me for a referral.